And the reason we put together, construction environmental claims, I've done a lot of construction defect work, and now I'm doing a lot of environmental work, and I realize there's a lot of overlap with some of the issues that we see. On the coverage issue, on the claim side, how you analyze these cases, how you evaluate them, what sort of status reports the adjusters are looking for. And so you'll see as we go along, there's actually a couple points where some of the things we say apply for both, or a lot of things we say are going to apply for both construction and environmental. Of course, red flags in any coverage issue, one of the things we're talking about, or some of the things you look for are missing dates, or dates that are obviously not real. If you ever done, probably all of us have started off with auto wreck work or done some auto wreck work. And after they do the, who the plaintiff is and who the defendant is, the first thing they do when they talk about the accident is what? On or about X date. They always give you the date. It's like the anchor point, okay? In construction case, if you have a construction case, environmental case, any case of any complexity, and they don't start off with a date, they don't give you a date, that's a red flag, okay? And maybe they don't know. They don't know when it occurred. They don't know when the damage first, started, which obviously has implications for coverage issues, what policy is going to be triggered, has implications for statute of limitations, statute of repose even. So anytime you have a missing date, and we see that fairly often, you just don't put the dates in because they're not sure when it happened. Environmental claims, they're not sure when the release was. So anytime you see that, obviously that's a red flag. If you're talking about a toxic tort claim, or really any type of claim, if you have vague or general references to the type or the nature of damages, what is the injury, that's always a red flag. We're going to talk about pulmonary injuries later on and how easy it is to allege those and pretty difficult to verify that somebody even has an injury. So that's always a red flag. And then one we see a lot, obviously in construction claims, environmental claims, is you're going to have multiple defendants. And what the plaintiffs will do is they'll list all these defendants, say who they are, won't really say what they did on the project or how they were involved with the environmental contamination. They just list them all, and then they refer to them all as defendants in general. And we hate that. We have kind of a standard response in our answer. We actually object to using the word defendants to mean we all acted in concert or we're responsible for somebody else's damage. But it's kind of shorthand for plaintiffs in the complaint. They don't specify who exactly did what. So that's a red flag. How do you address that? Obviously, informal requests. As attorneys, I'm always amazed. I always do this. When I get a complaint in, one of the first things I do is call the attorney on the other side. And I'm just, kind of friendly. Hey, I'm Roy Shelley, got this complaint. I don't really know much about it. Tell me what's going on. And plaintiffs' attorneys, like most attorneys, they like to talk. And they'll just tell you everything they know about the case. And you get a lot of good information that way. But of course, if it comes in on the claim side before it's litigated, don't be afraid. As a claims adjuster, just call up the attorney and say, tell me what's going on. May fill in some of those blanks we talked about. Once you get into the litigation, if you can't get more information out of anybody, you can always be a little more formal and file a pleading, a motion for a more definite statement. Some states have, call it, you move for a bill of particulars or something like that. But there are ways you can get more information. Obviously, you have formal discovery to get more information. What happened, when, and who did it. When you get to the end of the trial, you can do the special verdict forms, of course. But you have to be careful there. If you've been involved in litigation and there's an issue with insurance coverage, you have to be careful that you don't create a conflict between the counsel you hired to represent the insured and the fact that the verdict form may create an issue regarding what damages are covered and what are not covered. So you have to be careful there. Denial letters. The last thing I'm going to say about this before we get to Trey, when you're writing a denial of coverage letter, you're creating evidence, okay? So you have to look at that from the viewpoint of a jury. How is the jury going to take that when they see that letter? And if you see most coverage letters, you have a little template, things that you are going to put in that letter. And all too often, I've seen the last thing you say in an insurance coverage letter is what? As an insurance adjuster, I'm not waiving any other defense that may come up or, any other, claim that there's no coverage or anything like that. And you don't want that to be the last thing a jury sees. Sometimes what I've seen now is the trend is to let the attorney write the denial of coverage letter. And so what I always do, I say, you know, look, we appreciate the client's business, because that's what it is, but we have to be cognizant not to do a disservice to all of our clients by paying for claims that aren't covered. And then the last thing I say is, if you think I've overlooked something or misconstrued something, please let me know. And anytime there's correspondence going back, I always end with that, because at some point there's going to be litigation, and I want the last letter in the file, the last evidence before the jury, to say, look, if I've missed something, let me know. Because then if they've hauled off and sued us or brought us in court, then they didn't respond with, you know, what they think we've missed.